This is the Power of Permission podcast, brought to you by Privacy Pillar. This is the inaugural episode. Today's focus will be on why auto dealerships need to pay attention to privacy. Listen, it's pretty simple. If you care about your customers and you care about keeping more of your hard-earned money, it doesn't matter what business you are, privacy needs to be something you're really thinking about. And of course, Privacy Pillar is here to help. We have a number of experts on today's episode. We're going to start off with founder and CEO of Privacy Pillar, Dharmesh Patel. Dharmesh is a seasoned software engineer and digital advertising expert with over 15 years of experience in the industry. With a deep understanding of the evolving landscape of digital advertisement, Dharmesh has played a pivotal role in revolutionizing consent management solutions for businesses. Representing dealerships today is Mr. Tom Kline of Better Vantage Point. Tom has successfully concluded nearly 1,000 customer and employee complaints and lawsuits for the number one Chevrolet dealership in Virginia. As an innovative expert in dealership dispute resolution, compliance, and risk mitigation, Tom's unique results-driven methods for customer employee complaints, compliance, and risk bring fast and successful results. Legal expertise is provided by David Katz of Weissmann Zucker, Euster & Katz. David Katz serves as counselor and advisor to the C-suite and general counsel for both public and private companies. David previously served as senior legal counsel in the corporate law department, advising a Fortune 1000 publicly traded company in Atlanta, as a Baltimore City prosecutor, and as a judge advocate in the United States Army Reserve. He speaks and writes on matters relating to technology, privacy, and data security. Also attending today's podcast is Rinto John, our venerable and always positive business development lead. When you're ready for a privacy solution, a robust end-to-end solution like Privacy Pillar, Rinto's the guy you're going to talk to. He's going to take care of you. And of course, I'm your host, Boyd Stough. Let's jump into it.
Hi, everybody. I'm Tom Kline. My company is Better Vantage Point, otherwise sometimes known as Tuck the Octopus. So I'm a former car dealership owner for 30 years. My family's been in the car business since 1925, so almost 100 years. Next year will be the 100th year. And I help dealerships with risk and compliance. So I try to make sure that I've said that running a dealership or running a business is like trying to tuck an octopus into bed, and the tentacles keep flopping all over the place. So I'm the guy who helps tuck the tentacles.
Brilliant. Wonderful. Couldn't have anybody better to help us work through the subject of, or the intersection of, auto dealerships and consumer data privacy than Tom. Absolutely nobody better. So with that, I want to start here. Tom, when you and I started talking, there was this question like, well, why do they need it? Right?
Right.
So, I mean, it really comes down to auto dealerships spend a lot of money attracting people to their dealerships. On average, about how much do you think the average dealership spends? Just, I mean, all manner of marketing.
Between the smaller ones are going to be between 10,000 and then up to 50, 75, 100,000 a month. I mean, it can be exorbitant.
And it's driving these people, they're driving these people back to their websites primarily, right? Because they're trying to get them engaged with the
process, with the sales process. Yes, that's correct.
What does that sales process look like, Tom?
Well, it literally varies with every dealership. This morning in automotive news, I read there are more than 18,000 franchise dealers in the country, which represent 30,000 franchises. And so it varies from dealerships that just want you to call for price, or dealerships that want you to fill out a form, or dealerships that you can go through the entire process, digitally. So it really runs the gamut from pillar to post as far as that's concerned.
Right. And from your perspective, now that you have certainly a deeper appreciation of consumer data privacy, why do you think automotive dealerships even need to be thinking about this?
Yes. So in the last 6 months, there was a New Jersey dealer who was sued by a California customer. And under California law, or under the federal law, you have to comply. Dealers, even if you're not in California, my understanding is, and you guys will correct me because you have a lot more expertise on this subject than I do. But if a California customer shops your website, then you become liable under California law to have to comply with those privacy requirements. And without a product to track all of what happens in the consumer data that you're actually collecting, then you expose yourself, as this New Jersey dealership found out, and they're currently undergoing a class action lawsuit as a result of that.
Wow. And David, that's really a great place for you to jump in and kind of clarify that. I mean, very few people understand how you can have all these different jurisdictions have their own laws, and how those laws might apply to, a dealer in New Jersey. Why should the dealer in New Jersey have to worry about, say, CCPA, which is the law out there?
Yeah, no, I mean, there's incredible concern among both federal regulators and then states that are passing laws designed to protect the consumer. And all of this is from a consumer protection standpoint. And so there's the risk of consumer privacy class action, but also regulation from state AGs and enforcement actions. And many of these state statutes, as they're written, give the power to the regulator, who is the state AG, to enforce the law. So in some cases, there may be the ability of the individual consumer to bring an action, but in some cases, in some states, it may be the attorney general. And so there's just a big emphasis on giving individuals more ability to manage their data, to have an input and say in terms of understanding what a data owner has about them, and giving that consumer the power to delete it, to have access to it. And that's where you're seeing a lot of the regulatory requirement arise, is forcing individuals that are collecting data to be able to manage it very closely and have some ability to track it, to audit it, and to provide it back to that consumer. And that's why the software that you've created is pretty effective in the market in being able to accomplish those objectives consistent with these coming requirements. And most people don't appreciate sort of the technical nature of being able to go into their database and comply with these requirements and rules. So to answer your question, it's really a national issue. And just like on the state data breach in the state data breach laws, you're really bound by where that customer lives and the laws that apply to that customer as they're doing business with you. So it's challenging. Yeah.
So let's brass tacks here. You're a dealership. You're spending anywhere from $10,000 to say $75,000 a month, reaching out to the world, right? Asking them to come back to your dealership, right? And go through a process. It could be trying to get you to ultimately get on the phone and have a conversation with the salesperson. It could be collecting just certain, we call personally identifiable information, or PII, right, to carry you through a sales process and get you to the dealership, or could be trying to drive you through a fully digital process to buy a car. But in any case, there's a massive amount of money being spent driving a massive amount of attention back to your dealer. No idea where these people are coming from, right? So it could be coming from California, where they have CCPA, and you could end up in the situation that the dealership in New Jersey is in, right? So these are things to be thinking about. Now, Dharmesh, there's a lot of layers to this. There's a lot of layers to this onion you got to peel back, right? It's not just as simple as they get to your website. What happens to that data when it gets to a website, and where does it go, and what facilitates that flow of information?
So, talk about data data on the website. There's dealerships are spending a tremendous amount of money to get people on their websites. Once they get on a website, there's so many things that are happening. Dealerships are probably using for analytics, marketing, retargeting, advertisement, collecting, asking for more information about their first name, last name, their email address for communication. So data ends up in so many different places. It might go on an analytics website or external analytics site, which is Google Analytics. Most of the companies uses. You might have an internet analytics tool. Also for retargeting, you might be sending this data to different third parties as well. So data is basically, as soon as it comes to your site, it dispersed into 10 to 15 different locations. Now, without consent, it's just free for all. right? That's why these laws are being created now. That hey, collect consent, but mostly the U.S. regulation of CCPA, CPRA, all is opt-out regulation. So you should have a way for people to opt out of all this tracking and sharing the data. Then once the data gets in a different system, a person decides to ask you to opt out or remove information, you should be able to go back to all those different systems and should be able to remove people information from your system entirely.
Yeah, and I want to just say all of you have touched on something very important, which is that you, the dealer, are spending a lot of money to drive people to your website, and there begins the issue. You talk about an octopus, right? Something that's going to be very difficult to talk without the right processes, and which is really a David Katz, a lawyer kind of concern, right? Does your dealer actually have all of the processes in place, all of the legal sorted out? That's really important. And then you need a system. You need a system that allows you to be able to track all of that data, gather consent, and track where that data goes and what databases that information ends up in. And here's the other thing, David, I want to kind of shift over to you. If I'm a dealer, am I liable only for the data I collect, or am I also liable for the data that I'm sharing to other people?
Yeah, I mean, we've seen, the emergence in a lot of the state laws with provisions to bind the third parties that are the recipients downstream of the data in the contractual process. But I want to touch on something Dharmesh said that I think is worth sort of emphasizing, is there's an entire back end kind of data ecosystem that exists that the data owner may just not even be aware of. And it's complicated, and the data is passed from party to party. It's sold, it's reprocessed, it's resold. And that's just something that's occurring sort of naturally as the web operates. And for an operator to really not understand that, or to try to manage it on their own, it's very difficult because it's very technical and it may not be readily apparent. And that's why we're seeing the emergence of these kinds of tools that exist in the market to be able to manage the kind of back-end data flow. And the back-end data flow is what has the attention of the regulators, because they don't like the fact that the consumers have no visibility into what's happening downstream. And that's why you're seeing the regulation begin to develop.
And David, let me kind of capitalize on that and ask you this. Does it make sense? Is it rational to say that if I'm spending a lot of money as a car dealer, as an automotive, especially a larger one, okay? I'm spending a lot of money, $75,000 a month, pushing people back to my website. And that information comes in through my website and it ends up getting distributed like this. In effect, if I don't have my legal tidied up, and if I don't have a system for managing the flow of that information, tracking it, being able to respond in a timely manner according to law, am I paying a lot of money to open myself up to liability?
Yeah, I mean, the best way to explain it is it's poor asset management. 100 years ago, people were dealing with oil and gas and gold. I mean, the data is the lifeblood of the business. And so if you're not managing that appropriately, you're really exposed to your most valuable asset being diminished. And that's really the bottom line in terms of, focusing on the compliance piece of this, I think.
That's a really interesting way of putting it, don't you think, Tom? Asset management. I mean, data is probably the most valuable asset any dealership has, and what measures are they taking in order to protect that asset?
Yeah, it's interesting because last year was kind of the year in the car business for the customer data platform, and the otherwise known as CDP. And these customer data platforms are designed so that the dealer can take control of their own data and not be at the whim of all the third-party applications. And as David said, this information, unbeknownst to the dealer, they put cookies on the website, they resell it to other dealerships, they resell it. It just gets regurgitated and resold so many times that all of a sudden a customer who inquired on your website all of a sudden is being contacted by other dealerships, and they only contacted on your website. And the dealers don't even know, some dealers don't even know that. So I think it's important for dealers to consider when they're thinking about PII and they're thinking about where their data flows, to answer your question. I think they need to consider whether a customer data platform and taking control of that third-party data is right for them, number one. Number two, another consideration about tucking the octopus here is if they do get sued like the dealer in New Jersey, is do they have the proper insurance to cover a lawsuit like that? And so I'd encourage the dealerships to contact their insurance professional and have them do an analysis. Of course, it depends on what the allegations are and how they're crafted will really depend on what kind of coverage might kick in. But for the most part, you can take a look at your coverage and see whether this type of or these types of breaches or misuse of data is covered in any way.
I want to, David. There's been a number of issues where, especially in California, where these laws are written such that maybe a consumer data privacy issue isn't the way in, right? But in terms of the ability for the average person to directly bring a lawsuit against a dealer, okay?
Right.
But if they can allege there's been a data security issue, that opens the door, and then they're able to kind of pile CDP on top of that.
Yeah, I mean, it really just starts like any other, consumer complaint. You have somebody who is somehow upset that their data is shared, or they don't recognize how it is that their data wound up with another party. And that generates a complaint, and it could generate an investigation by an attorney general's office. And they've spent, really the last 4 to 5 years staffing up with lawyers that specialize in this area, that have some technical expertise and background, and they'll issue a demand and to ask questions about the operation. And that in and of itself can be time consuming and can be, frankly, it can be scary, because the AGs are really trying to identify, and forgive me, large sums of money of individuals that they have the ability to investigate, and that's a risk. So being buttoned up and having a good program in place, knowing what your risks are, knowing what laws apply to you, and just having a general sense of compliance. And to Tom's point, an insurance policy that covers the regulatory risk with a broker who really understands the market and knows the kind of coverage that you need is very, very valuable, and is a very good hedge against the risks that exist out there.
Let me tell you,
if I could just follow on David's comments here, 2 things. Number one way that I've seen that plaintiff attorneys pile on here is by using what's called the UDAP statutes, which is unfair, deceptive acts, abusive acts and practices. And so that's often a kind of the gateway drug, if you will, of how they get in here. They just say what you're doing is abusive and unfair, and they'll allege Consumer Protection Act violations, and they're off to the races. So and so I think that's important to consider with what David was saying. And also, while we're talking about scary things, the AGs are often will issue what's called a litigation hold on their data. And a litigation hold means that the dealership can't delete any of their data because it has to be available for discovery. And I'm sure David can speak more to that, as he and you are the 2 lawyers on the call. I'm just the compliance and risk guy for the dealerships, but the burdens can become very onerous for such a small issue and something that's fairly easy to solve.
And to that point, first of all, I want to say, yes, the machine is certainly gearing up. There's some well-paid attorneys looking for opportunities. Let's be real. David's not one of those. He's on your side. So get to know David if you're out there and you want to dive into the legal. But that's a really great point, Tom, is that if this were an insanely expensive, insanely complicated thing to address, that'd be one thing. But it's not. They're incredibly competent people, and there's competent platforms that can help you address this rather painlessly, honestly, and if I may say, very inexpensively. This is not something you need to be doing a whole bunch of mental gymnastics trying to rationalize avoiding. Dharmesh, I want to kind of turn it over to you. What does Privacy Pillar offer, and what are we talking about maybe in terms of cost? What's a range?
Right. So going back to Tom's and David's conversation, which is CDP and first-party data, how the first-party data get collected, and what are the AGs are looking for? They're looking for certain things like how are you managing current privacy regulations? What kind of tools you have in place to manage privacy? and security within your infrastructure. And if you can prove that within that you genuinely care about user privacy and care about security, then there should be no for you to worry about. But as soon as if you don't have any of the privacy regulations tools in place within your arsenal, then there's a chance of getting a higher fines. Let's put it that way. In terms of privacy pillar, what we provide easy way for people to collect their first-party data or third-party data, however you want it. It collects the consent of the user as soon as it comes to your website or comes to your web app. That allows you to either a consumer to opt in or opt out of the personal information, marketing, advertisement, etc. That allows you to actually take, as a company, to take an appropriate decision, what you can do with that particular data. If your customer decides to opt out of marketing, you should not store that data in marketing or analytics, anything like that, right? If a person decides to opt out of advertisement, you should not be share that data. To David's point, it goes in the whole ecosystem of SSPs and DSPs of digital marketplace. It should not end up to any of those places. If you care about privacy regulations, the international regulation, GDPR, you should not even load any of the marketing and advertising scripts on your website prior to getting the consent from the user. Right, and so we allow tools for companies to be easily compliant, to collect the data. And what happens, user decides to opt out of that information later on. So delete my information, remove my information, correct my information. So we also have a process or tool developed for DSAR that allows company to easily manage those requests as well.
And DSAR is data subject access requests.
Access requests, yes.
Boiling it down, it's like this, okay? When that information comes to your website, if it's not consented to, you don't have a record of that consent, or you haven't presented that person with an opportunity to consent, there begin some problems. But there's also this back end of being able to track where that information goes, and in a timely manner, should anybody ever reach out to you and say, I want you to delete my data, I want you to export it, I want you to change it. Instead of having to, go through all these databases one at a time manually, to be able to just simply check all of them, find that information, and respond to the person in a timely manner, it evidenced that right to the AG's satisfaction. Right? That's what it's about. Now, of course, there's a whole other layer of this, because your business, Tom, the automotive dealership business, looks to me to be a pretty complicated, convoluted one, right? And you're probably going to want to have somebody who's expert on all matters legal relative, actually consulting with you, working through those things. And I think David's a great guy to do that. And of course, listen, all your compliance needs, your man's Tom Kline, absolutely, all day. Now, if you're interested in having a conversation with Privacy Pillar, anybody you see on the screen here today, reach out to Rinto. Rinto, how can people reach out to you? What's your email, buddy?
You can reach out to me on sales@privacypillar.com, which is our business email ID, or they can directly reach out to me, but at rjohn@privacypillar.com.
All right, great, wonderful. Listen, guys, thank you so much for spending some time today. We spent more time than we thought we would, because it was more interesting than we thought it would be. What do you know, right? And we'll have more of these conversations. But I want to say thank you to everybody for being here. Thank you for taking a minute to check this out. If you have any questions, Rinto Sales, privacypillar.com. And you guys have a great day.
All right, guys. Thank you so much.